we and our speakers are fine to continue as well. So as I said, good morning. My name is Markus Schmidt. I'm the General Manager of the European Company Lawyers Association. Before we get started, I would like to give you some housekeeping rules here. You see this tool. I hope you all can hear us well and see us well. You have a chat function in this tool to the right where you can ask questions. I'm pretty sure Helena is fine with taking questions all through her speech as well. And we can also have questions in the aftermath after we had our little interview. Topic of today, of course, is Brexit. But before we start with that, a little bit of an advertisement part just for the one of you or two of you that do not know about the European Company Lawyers Association or the Law Society of England and Wales. The European Company Lawyers Association is an umbrella association, so an organization of organizations located in Brussels for 37 years now, advocating for the profession of company lawyers all across Europe. The ECLA has 23 members. As it is an association of association, it has only associations as members, as you can tell, and the Law Society is one of those members. ECLA itself, as I said, advocates for the profession of company lawyers, but also offers a vital platform for best practice sharing, for trainings, or for networking. Whereas, of course, as you all know, the networking part is a little bit low at the moment due to the current health crisis, but we are very optimistic that this will start again very soon. The Law Society of England and Wales is one of the members of ECLA as well, actually one of the founding members back in 1983. And as most of you are from England know already, the Law Society of England and Wales is the professional association that represents and governs solicitors for the jurisdiction of England and Wales. It provides numerous services and support to solicitors in this jurisdiction and beyond, of course. And it does also serve as a sounding board for law reforms. And besides, I think, Helena, multiple offices in the United Kingdom, it also has an office in Brussels, actually very impressive office. I've been there a couple of times. And our guest today, Helena, is the head of the Joint UK Law Society's office in Brussels. And a warm welcome to you, Helena. I'm very grateful that you are here today and inform us about Brexit. So Helena, as the head of the Joint UK Law Society's office, is an expert, of course, on EU legislative processes and institutional frameworks. Helena also leads policy development for various Brexit-related issues. So I'm pretty sure Helena can tell us a lot for this today. Maybe should we get started, Helena, with a question, if you explain a little bit in detail what exactly it is the Law Society's Brussels office does.
Good. Thank you very much, Marcus, and good morning, everyone. Apologies, I may look a bit flustered, but indeed we had a bit of Wi-Fi issue this morning, and I hope this will be holding. But it looks good so far, and I'm looking forward to the next hour with you. Our office here in Brussels, we are essentially the representation arm of the solicitor profession here in Brussels. So our key tasks have usually been, or traditionally been, of course, advocating solicitors' matters, representing their issues towards the EU institutions, the EU stakeholders, EU bodies. So we are essentially a small lobbying office, you could say, in here. Also, we, of course, act as a bridge between the sort of Brussels-based and EU information, bringing that to the UK, to our members, as well as then bringing the talent of our membership from the UK here to Brussels to help us to discuss various issues. Brexit, one of them, but of course we work on other issues such as anti-money laundering legislation, IP legislation, access to justice issues in a European level, etc. So we connect with those law societies' priorities in the UK, bringing them back, the expertise and the depth of involvement that we have with certain issues to here to Brussels. And indeed, we represent all three law societies here. We have the Law Society of England and Wales, which we are actually their office, but we also have a service contract with Scotland and Northern Ireland. So we can speak in a voice of the UK solicitor profession here in Brussels.
Great. Well, that leads us to the topic everyone is waiting for today. And I think it's a topic everyone is both tired and excited of due to the time constraints we all look at. Helena, let me just start. Where do we stand with Brexit?
I think tired and excited is a very accurate way of describing it. It's been a long process to get here. But on the other hand, what would you expect? It's such a huge change in a direction of cooperation, European cooperation for the UK and Europe. Where we are at the moment is that in the beginning of summer, there were three issues that were on the table. That was the level playing field, the governance, which is the overarching institutional framework of the agreement, and the fisheries. We've heard that there's now a breakthrough actually on the governance issues. So there is an agreement between the UK and the EU on the architecture of the agreement, on the economic relationship. But what we have, of course, now is the fourth issue has arisen, which is the internal market bill. So that still needs to be, so we're back to three essentially with the level playing field, fisheries, and now the internal market bill and the possible infractions of the withdrawal agreement.
Interesting. Yeah, this withdrawal agreement, this is something that, of course, has been surrounding us for the last couple of years. However, this internal market bill is pretty new. And I know that there are opinions in the market about this internal market bill, that this might not only be a breach of this withdrawal agreement, but also a breach of international law at all. How does this comply with the rule of law at large?
Well, in our view, it doesn't. The current proposals that we have on the table, they do not, because there are clearly counterindications to the withdrawal agreement. And like you said, if there's a withdrawal agreement breach, this is an agreement that has been agreed in good faith between the EU and the UK. This is a breach of then international law, an obligation of following international law, which is then what we would see as breach of rule of law by the law societies. In particular, with the Law Society of England and Wales, I worked with their campaign to either remove or change those clauses that would be potentially in breach of the withdrawal agreement, international law and rule of law. So we are approaching the UK Parliament, we are approaching our stakeholders, we are approaching essentially asking anyone to join our campaign to make sure that rule of law and international law and through that the withdrawal agreement is respected. We see this as a great danger to the UK. It's of course a danger that if you explicitly break your international obligation, if you admit that you're breaking your international obligations, this makes you less reliable as a business partner. So we have a lot of important trade negotiations ongoing. So of course we can see that other negotiators are looking at this as a potential problem in their negotiations. You have 1 year since the withdrawal agreement has been agreed, and now the government wants to unilaterally to depart from some of the provisions. It's also problematic for us because we are very proud of our jurisdiction. We are very proud of the fact that the rule of law is observed in the UK, that if the UK signs an international agreement, if it signs a piece of binding legislation, this has to be complied with. So as a profession, we are also very profoundly impacted by this development. So therefore, we are campaigning to change it, to make sure that it does not change unilaterally the withdrawal agreement.
Right. And speaking about the free trade agreement, can you give us a little bit of an update there regarding the current status? So what is currently negotiated under the FTA, the free trade agreement? What will it solve, and what will still need to be solved?
Well, that's actually a really good question, because the FTA, which everybody's talking about, that's the cornerstone of the future economic relationship after the transition period. It is actually, compared to the issues that are on the negotiation table, it only deals with a very limited number of issues. It's mainly the goods and services. How do they work in this economic environment? So, for example, of course, we would have in parallel negotiations coming from on the criminal justice aspects or security aspects. This is hugely important for the both parties. But I think it's good to remind, and thinking that this is an in-house lawyer audience, for businesses, it's the FTA, what is being negotiated. It really does not solve everything on the table that we would need to be looking at from the commercial perspective either. Two issues in particular that we have identified from the law society perspective are enforcement of judgments in civil and commercial matters, and data exchange. So we know that the enforcement of judgments does not fall in the scope of the FDA, and it's possible, more probable, that the data adequacy will not either. So these will still need to be solved on top of the FTA. And if we look at it, that the end of transition period is at the end of this year, it gives us a very little time to deal with all those other issues that would need to be solved on top of the goods and services FTA.
Right. So those two things I would like to go a little bit more into detail in the next, let's say, 30 minutes or 20 minutes. So the enforcement of judgments and data protection. But speaking about the enforcement of judgment, which is obviously not part of this free trade agreement, how does enforcement of judgments support the business activities then on both sides of the channel?
I know traditionally this has been seen as a very much a lawyer's issue, the enforcement of judgments. It's been a sort of a relatively small group of lawyers that has been dealing with it. It's a geeky area of law. But actually, what has been done in the European area when it comes to enforcement of judgments has been quite very, very advanced, I would say, because what we have is a system where if you have a cross-border dispute, and businesses, if you are engaging in cross-border operations, there might be arising disputes, whether the goods were delivered in time, whether there were other breaches of contract, whether there was negligence, etc., etc. So what we've had in Europe have been the Brussels regulation for the EU, and then the Lugano Convention for EU EFTA relations. And these have actually created an almost automatic system, a very predictable automatic system for enforcement of claims. So businesses didn't have to use quite a lot of money for procedural matters. So you could essentially use the money in the substance of the dispute rather than to litigate what is the right jurisdiction, how do I enforce this, how do I access my dues in another country. So by having this very predictable system, that has actually brought down the cost of the litigation, and that has been the sort of the really fundamental point for businesses. How this sort of very legal geeky world is combining with the business world, and that's something that will not be available there anymore.
Mm. So what is the situation then for businesses that have adopted a choice of court clause? Are they going to be valid or not?
Well, that's a very good question. If there is no agreement in this area, we would look at initially a national law in enforcement of judgments or even in questions of jurisdiction. So Article 67 of the withdrawal agreement sets this out very clearly with regard to choice of court agreement. So when you have a choice of court agreement, let's say it's agreed 5 years ago, when the UK was in the EU, the UK was in the Brussels I system or Lugano system. This choice of court agreement, if the litigation starts next year, it does not fall under those mechanisms anymore. It actually, the main point, or the key point, is the date of the start of the litigation. So if you start litigating after January 2021, you will have to use maybe national law to decide whether the choice of court agreement is valid, and then how to enforce this judgment in the other jurisdiction between EU and UK. Now, there is the Hague choice of court agreement convention from 2005, and both parties will be are going to be parties to this in 2021. So this does enable you that if you have an exclusive choice of court agreement, which means that it's not hybrid, which is some issues are to be litigated in one jurisdiction, other issues in other, but you have exclusive choice of court agreement that all issues one court in this jurisdiction.
Mm-hmm. What about? Yeah, sorry, go ahead.
This is a very technical point, and I think good to make. In this case, you may be able to use the Hague 2005. But the second question that arises is that when is your choice of court agreement or clause agreed?
Mm-hmm.
Because the Hague applies only to the agreements that have been agreed during its period that it has been enforced. And EU became a party in October 2015. UK says that from October 2015, you can rely on the Hague Convention in the UK side. However, the Commission has said that actually in the EU, they will be looking at only choice of court agreements after the UK exits from the EU system and enters into the Hague system as an independent party. So that means from January 2021. So that means that you will have to look at two things: whether you have a exclusive choice of court agreement to fall into the Hague processes, which facilitates you, or that this choice of court agreement may need to be re-agreed from January 2021 onwards.
Okay, interesting. Does this also? Yeah, well, let's see. Exactly. But does this also apply for the choice of law clauses that might exist in existing contracts?
That's where the answer is much simpler. No, because
Okay.
because we have their own one regulation in the EU side, and that allows universal jurisdiction. So if somebody would like to use, let's say, Russian law, they can do that. The EU courts will have to recognize this as a valid, if it's done according to the rules, as a valid choice of law. Similarly, these provisions are being actually adopted in the UK side. The only question what I do have here, and just something to point out for you as a risk factor, is that, of course, if your choice of court agreement is linked to the choice of law agreement, choice of court agreement part falls, and you end up litigating in another court, you may have to litigate in a foreign legal system. And that, of course, increases expenses. It's a risk.
So is that the only solution, or do you see other solutions there?
Well, solutions actually in this area, in the recognition and enforcement of judgments, we have the Lugano Convention. I'm seeing already there's a comment. I'm
going to come to this soon, yeah.
Yes. So there is an easy solution. The UK is already party to the Lugano Convention. It is slightly different from the Brussels one, but it really delivers. It provides the equally wide range of recognition enforcement of judgments. It provides the jurisdiction rules. It provides the predictability, almost the same level of automaticity as the EU regime. It is an international convention, so there are small differences, but it would be indeed almost the ideal solution. Where we are with the Lugano Convention now is that the UK government has actually applied for the Lugano on the 8th of March this year. And the EFTA countries, because it's a convention between EU and EFTA countries said they would be supporting the UK's application. So the question is now relies on the EU to accept to the UK application. The problem is that Lugano is only open for EFTA and EU countries as a right to join. If you're outside, and the UK will be outside of EU and EFTA regimes, so it will have to get the consent of the parties. And the EU so far has not moved on this matter because first comes the economic agreement. Right. So we hope that the Lugano will be there if and when economic agreement is agreed. It's going to be on the list of issues this year to be solved. And that's what we are working hard on. If there's no Lugano, we will have a gap when all the claims will go to the national law. That will increase, of course, the cost of litigation, like I explained, the procedural issues. It will also increase the risk of that you will not get your claims enforced. The national provisions may, for example, look at the amount of damages that have been awarded, whether that accords to the national level. National laws usually open up a lot of these options. In some rare cases, you might have public interest clauses, which would then delay or make the enforcement less effective. For example, in employment cases, I could see that arising. In some jurisdictions, Nordic jurisdictions in particular, there is no enforcement of judgments without a bilateral treaty. Uh-huh. So all this needs to be taken into account. So that would be the case if Lugano is not agreed this year for January 2021. We may see then that the EU and the UK will move on to the Hague Judgments Convention, which is a new convention from 2019. Now, EU is not a party to it yet. There's no ratifications. It's very, very early on. So it remains to be seen how important the issue is for the EU and the UK to agree quickly to expedite it. The EU is looking at the matter at the moment. There are consultations going on. But from our perspective, it's not as effective as Lugano because it doesn't include the jurisdiction rules. It's much more limited. It doesn't include IP law judgments, antitrust, competition law, employment. So it's a much more limited framework. But of course, at that situation, it may be the alternative that's available then to facilitate things. But things will get messy, to be short.
Seems like you're not getting bored at all at the Law Society taking care of these kind of questions. Before we conclude the topic of enforcement of judgments, we have two questions from the audience, which I would like to read out. The first one was from wait, now it's switched off. Okay, I'm going to the question from Cecilia from Stockholm. If you have agreed on arbitration, then the choice of court problem will not apply. Is that correct?
That's correct. Then you apply the 1967-68 New York Convention on Arbitration, and that international convention. So, Cecilia, you're absolutely right. That's an option.
Cool. And the second question came from Bill from Anderlecht, and that was the question, is the EU still blocking UK accession to Lugano?
They have been very political about it. It's actually really curious because you've probably seen the Financial Times reporting on the Lugano Convention, how the Commission has told the reporter that the Lugano Convention, oh no, we maybe we won't agree to it because it's an internal market matter. It's not. It's an independent convention. That's our view. It is open to accession for other countries. But then the thing is that when the Commission is pinpointed on this, so we've had our members, for example, in roundtables with the Commission officials, they make it very clear that the decision has not been made yet. So what we see is that this is part of the sort of the bigger political game now, that the Commission views, and in particular Article 50 Task Force views the Lugano Convention as being of such a strategic importance to the UK and particularly the UK legal profession that they can hold their decision to accede to the convention to see what happens with the broader negotiation. So it's part of the negotiation puzzle. For us, from our perspective, this is a really unfortunate way of looking at things because when we did this analysis already in 2016, 2017, when we were looking at the referendum, when we were looking at the consequences of the referendum, we actually...
Helena, hello? It seems like we have some technical difficulties. Helena, at least you froze on my side here. Can somebody just maybe write in the chat if it's only me that sees Helena frozen. Sorry for this interruption. Yeah, it's frozen here too. I'm very sorry for that. I hope she will be back in a second. We see she just left it. When she comes back, then we're going to go to the very interesting topic of perfect. Here you are.
As I mentioned, we've had huge Wi-Fi problems this morning. We're not going to talk about data soon, but hopefully there's no connection. But sorry, just to finish the point, from our perspective, the Commission dialogue is really, it's not an accurate description of the problem. This is a problem particularly for medium-sized businesses who need to litigate their cross-border business. For them, it's the having the available resources to get those specialist lawyers to deal with the procedural law questions, which they haven't needed to do. It's going to be a cost for them.
Okay.
I hope that makes sense. Sorry about that.
We will take questions at the end again, and I would like, just because of the time, to come back to the enforcement of judgments, maybe later collected with all the other questions we have. And before your Wi-Fi Brexits again, I would like to continue with data protection. And you talked about this, that this is not part of the FTA as well. So what are the basic issues regarding data exchange in a post-Brexit world?
Well, the basic issue is really how to transfer data, that if you have business operations on both sides of the border, how to get the sensitive data into the UK outside the EU area. And this is, of course, this has been a hot potato within the EU with the GDPR, with the Schrems judgments. We'll come back to that, and all the concerns that we want to keep our personal data protected. Now, data adequacy would solve that to the great extent that then you could rely on this adequacy agreement. Things would continue pretty much as they do now. Without a data adequacy agreement from the EU, and this is the EU's gift to give. So this is a unilateral decision that the EU can take on basis of the data protection regulation. Now, without the EU giving that, there are still ways to continue, of course, for businesses. What we would be looking at in those cases are the having the standard contractual clauses, for example, that comply with the GDPR, or having the right business governance rules, which explain how you comply with the data regulation. Now, this is an area that we are in a little bit of flux on this. So we are currently building our guidance what having no data adequacy will mean. But those two mechanisms are still available.
Okay, and we had the famous Schrems II decision by the European Court of Justice, as maybe everyone here remembers, that has focused on the implications for personal data transfers, especially to the United States of America, but also to non-European countries. The question is obvious: how does this affect the United Kingdom after Brexit?
Well, we are still digesting it. It's an important judgment, but what I would say, it emphasizes the role of the data protection authorities in the EU, that they will have to oversee. So, for example, you have a standard contractual clause, or you have a business governance clause in your statutes, company statutes. The data protection authorities in the EU side would have to oversee, they have responsibility to oversee that you don't just say this, but actually you comply with it. So they've been given more powers and more responsibilities in the Schrems judgment to overtake this assessment work with you. And if they are not happy, they can, of course, they've always had the right to give fines, but they can also then stop your data transfers in a business level. And they would be looking at not only the business behavior, but also what happens in the legislative field, because this was a judgment that dealt with the US. And in this area, what's the EU-US disagreement or their tension is about the government getting access to data, investigative services having access to data, surveillance services having access to this data. So in Europe, we've tried to build the walls around this, but in America, this is in a different way. So essentially, the data protection authorities can then oversee this. How does this the corporate code that you have operate in a broader legislative environment and make decisions on basis of that?
All right, that sounds challenging. I would invite all the participants of today's webinar again. If you have questions for Helena, please join the chat function to the down right part, especially regarding the judgment, the enforcement of judgments, and of course data protection, all other questions you have regarding Brexit. But we have, of course, two more general questions as well to Helena here. Going back to the general terms, looking forward until January 1st, 2021 already. What do you expect in your personal opinion? What will be the best case and maybe the worst case scenario in a nutshell?
I always debate when it comes to Brexit, should I start with the best case or worst case? Because you always end up in a slightly depressed place. But let's start with the best case. You asked that first, so let's start with that. The best case scenario is that there is the limited FTA in place. It is going to be limited, in particular when it comes to services, legal services, professional services. The free trade agreements just do not have the same reach as the single market in this area. It's not going to be even comparable to what we have in the single market. We've been aware of this for a very long time, and we have been very clear that this places quite considerable limitations for us. But what's the good thing if the agreement is there is that you can continue to build on it. Then we would expect that there would be hopefully sort of better atmosphere in the negotiations. The UK has exited from this sort of halfway in, halfway out house, which is the transition period, and it would be in a more FTA world, which would allow the UK to start making its own choices. But also then that could allow further issues to be added and further agreements to be made. So, for example, in the FTA, we are not likely to see anything on mutual recognition of professional qualifications, which is hugely important for us. But then it might open the avenue to make another agreement on the mutual recognition of professional qualifications quite soon. Similarly, it opens up the Lugano option. It opens up the data adequacy option. It opens up all the possibilities. What we are trying to do now is make sure that the list is long, that our priorities are somewhere recognized on that list. That's our current work. And that's what I'm doing essentially today, talking to you about it, to make sure that you're aware of some of these quite quaint issues that are at the table. Worst case scenario is that there is a full breakdown of the negotiations. There is what is the non-negotiated outcome? That's the current terminology, alternatively called Australia option. So if you hear Australia or non-negotiated, that means that there's no FTA, there's no further facilitation coming. Now, of course, in that situation, the withdrawal agreement still continues to apply. So we have some facilitation for those people who have been taking residence for example, EU nationals who've taken residence in the UK and vice versa. So UK citizens who are residents in the EU, they have facilitation. There's the Northern Ireland Protocol, and that's it. Otherwise, we are in WTO terms.
Okay.
And future negotiations, who knows when they can start again.
That's right. That's right. So the Brexit saga continues at least for another 3 months, but it's been a tough road for the last 4 years, isn't it already? 2016. And it seems like the Brexit really shows everyone how complex such a topic is. My final question for you today, all the targets, all the participants of today, with all the background knowledge you have regarding Brexit and all the negotiations and the implications on companies, what are your 3 main recommendations for companies on both sides of the channel? So 3 recommendations for the business, how to prepare, how to get waterproof until January 1st, what to do.
I would say, of course, from my perspective, it is the enforcement of judgments. Check your check your choice of court clauses. Check that they fall under Hague 2005, that they are exclusive. Check if you can re-agree them in January. That would be the first thing to look at. And I know in majority of business you use choice of court contracts, so that already captures quite a lot. So if possible, try to make sure that they fall under the 2005. Please note, indeed, that there is a disagreement between EU and UK, how this is applied. So that's where the January, revisiting this issue in January is really important, to make sure that you have everything in place if you feel like you need to secure that it falls under the convention, then you re-agree it. Now, that's my first recommendation. Second recommendation is, of course, looking at your data processes, looking at that you have the standard contract clauses or you have the right governance clauses in your statutes. Have those conversations with the relevant EU data protection supervisors. They can give you help. They can give you assistance on how to make it so that you can still continue to forward data. And you can still operate in a similar way that you do now. That shouldn't be absolutely a huge thing, but it's an important thing to do. And then I would look at, really, it depends on the area where you are. What is your concern? Do you have issues on banking? We keep hearing now how the banks are starting to make their decisions on. So if you have, for example, assets or you are dealing with some financial services issues, have those conversations with the relevant banks, with the relevant regulators already early in time, to make sure that then you have a route to do things in another way if needed. So really check your business activities, supply chains, everything, where there's the UK-EU connection, and have those conversations. Put in a plan that in case if there is a very minimal FTA, which may not help, to be honest, at this point, or WTO exit, you know what to do. I think most of the big businesses have done this already. I know we were doing this last year 3 times. What did we do? The no deal exit preparation at the Law Society. So this year we looked at the end of transition. We are coming out with the end of transition guidances soon. And we are just looking at them on how to update them to the withdrawal agreement environment, and then looking at if some issues will fall because there will be an FTA or because there will not be an FTA. So what do we say in that case? So maybe that's my sort of final advice. There's a lot of help out there. We aim to help our members. We aim to help everyone. Actually, our needs are public. They are available in our website. So if you go to either to our Brussels office website or to our to the Law Society of England and Wales website, we are looking at building now guides on various issues, ranging from data to judgments to service of documents to taking of evidence to IP law, competition law, etc., etc., etc. So we are building those this autumn, and they will become gradually available when we have clarity as to what happens. But it's almost like a 2-track planning. I'm sorry to say we're still a little bit on that. That in some areas there might be solutions coming in which may help, but if those solutions do not come, or if they don't come on time, it's good to be prepared for the hardest possible exit.
Yeah, that's right. But that's great services you offer in Law Society as well. And it seems like the whole Brexit thing really kept us lawyers busy. So as an optimist, the last 4 years, I was always asking for a date when the UK will rejoin the European Union. But considering all the legal framework that has to be done about it, that will be another decade of work, I guess. But anyway, Helena, I thank you very much for answering those questions today. I see that there are no more questions in the chat for the moment, so it seems like we exhausted really all the questions here and answered it. However, yeah?
Sorry, there was one about the English choice of law issue and courts. You could have reasonably strong case for forum convenience. Indeed, you do, but again, you need to be able to argue that. That's the forum convenience is, of course, a very good, strong, flexible tool that you can use. And I would be saying that generally having jurisdiction in the English courts, that's not the issue. But the issue may be then on the enforcement side. So enforcing that judgment in a EU or EFTA country, if you need to do.
Great.
Yeah.
That's great. If you have any more questions for Helen, I'm pretty sure she's available on LinkedIn to be connected and questions to be asked. Same as for ECLA. We also recorded this webinar if your colleagues are interested into watching this later. And as Helena already said, there is multiple information to be offered on the Law Society's website, Brexit sub-website, if you have something like that. And ECLA is, of course, going to continue covering this as well on their ECLA website, as well as in-house legal. And so that's it for today. I would like to thank you, Helena, and for all the participants to join today. We have our next webinar in the ECLA Online Learning Center next week on the 30th of September at 1:30 p.m. Central European Standard Time. And it's going to be on the General Counsel report, A Bridge to the Future of General Counsel. I highly recommend that if you're interested in how the job of General Counsel is evolving over time. Then see you there next week on the 30th. You will find this on the website. And Helena, I'm looking forward to having such kind of discussion again very soon, where we can update the participants and the members of future Brexit developments. Thank you, everybody, for joining today. I wish you a great weekend, and thank you very much.
Thank you also from my part very much, Marcus, and looking forward to joining you again, and hopefully with a little bit of good news next time.
That sounds magnificent. I like that. Perfect. Have a great weekend, everyone. Thank you.
Good weekend. Bye.
Bye.